Firstly, I'll give a brief overview of ADR, arbitration and mediation with some real-time examples. Also, we will discuss about the role of mediator and arbitrator in securing ends of justice in the process of mediation and arbitration respectively. Thereafter, we are going to compare European Union and Indian arbitration and mediation process.
Arbitration and mediation de yaptı yani.
Yeah, that's right. Arbitration and mediation process, both of them. I would also like to draw your attention toward present situation of arbitration and mediation in European Union and India. Finally, thereafter, together we may do some brainstorming and discuss about this topic. So now to begin with, I understand I have an audience with a basic understanding of ADR, what ADR is, but still I would presume that we have a mixed audience over here. So I'll start with the definition of ADR, what ADR is all about, and I'll come to the mediation, then arbitration part. So to begin with, I want you to imagine a situation where two business partners have a dispute. They have two options. One is to take a case to the court, which could take many years to resolve. Second option is to use an alternative method, which helps them to resolve their conflict in just a few months. Which one do you think is better? Can I have an answer, please? Most of you would probably choose the second option. This is exactly why alternative dispute resolution ADR has become an essential part of modern legal system. In today's session, we will explore ADR in depth. We will discuss mediation, arbitration, their advantages, and how they play a role of justice delivery system. By the end of this lecture, you will have a strong understanding of how ADR is shaping modern legal system and when it should be used over traditional litigation. Now let's start by understanding what ADR actually is. ADR stands for Alternative Dispute Resolution. It refers to various techniques used to settle dispute outside the traditional court system. Instead of relying on a judge, a long legal procedure, parties resolve their disputes through negotiation, mediation, arbitration, or conciliation. ADR is widely used in commercial disputes, family matters, labor issues, and even in international conflicts. So, why ADR is important? First and foremost, we here in India have overburdened courts, and I believe there are a number of cases pending in European Union and in Polish courts also. So it helps judiciary to reduce the workload, because if every dispute goes to court, justice would be delayed indefinitely. Second important point is time efficiency. Court cases can take years and even decades, particularly in India, because I believe we have more than 50 million pending cases as on date. So it can take lots and lots of time. However, ADR methods often resolve disputes in a matter of few months, weeks, or at times in a year or a half. Third important point is its cost effectiveness. Litigation is expensive because of legal fees one has to pay, court cost, and there are some procedural delays. ADR reduces these expenses significantly. Apart from this, there is one important point of confidentiality. In ADR proceedings, especially in mediation and arbitration, the documents, the facts, the arguments are done in a private, and they do not become part of public records, unless of course the matter goes to the court in arbitration in an appeal. And the flexibility it brings, unlike formal court procedure, ADR follows customized solution between the disputing parties. So we have four method, ADR method. Everybody must be aware about that. Anyone would like to share or response? One is mediation, second is arbitration, conciliation, and negotiation. I believe lately, a day before yesterday, European Union has indirectly offered a negotiation to US regarding increased tariff issues. So these kind of big international issues can also be resolved easily through mediation, through negotiations between two countries. There is a case of Amazon versus Future Group in India, In 2021, Amazon and Future Group had a major dispute over a business deal which worth billions. Instead of approaching courts, Amazon opted for arbitration in Singapore. Arbitration panel ruled in Amazon's favor, and it impacted Future Group's business operations for a while. This case also highlights how powerful arbitration can be in resolving large-scale commercial disputes. This is a brief picture of arbitration, ADR. Now let's shift our focus to mediation, which is of course one of the most widely used ADR mechanisms. Mediation is all about finding a middle ground between disputing parties. It is particularly useful in cases where maintaining a relationship is important, such as a business partnership, a family dispute between a husband and wife, or a labor conflict, a conflict between employer and employee, where party would like to maintain their relationship. Today, mediation is widely accepted as medium for resolution of international commercial dispute because of its advantages. Mediation in India dates back to Vedic ages. In ancient times, if you see, there were disputes at village level, at town level, at community level. You used to have panchayats in those days. They used to act as a neutral third party and used to resolve the small petty issues. Recently, Indian government, by amending Section 89 of Civil Procedure Code on 1st of July 2002, made mediation as one of the modes of settlement in dispute. And Section 89 introduced to promote alternative dispute resolution. Similarly, Section 12A of Commercial Courts Act in 2015, which was amended in 2018, makes pre-institution mediation mandatory for commercial disputes. Any failure to comply with the new 12A section can lead to rejection of plaint under Order 7, Rule 11 of Civil Procedure Code of India. Similarly, likewise, mediation has deep roots in Poland. Mediation in Poland has roots in solidarity movement. I would be more than happy if someone can discuss or suggest anything about it, or rather improve and bring new facts during our discussion and enlighten me and other participants on solidarity movement. So with its legal reforms in 2005 and 2016, mediation has emerged as a primary medium for resolution of disputes in ADR. Solidarity movement provided a strong foundation for no winners, no losers solution through negotiations. Mediation in Poland is governed, regulated by Polish Civil Procedure Code. Like Indian mediation has roots in Indian Civil Procedure Code. So there are many similarities between two systems. Article 183.1 to 183.15 of Polish Civil Code provides for provisions related to mediation, and Article 184 to 186 regulates court settlements. Similarly, Indian Civil Procedure Code provides for settlement under Civil Procedure Code in a particular section. In 2016, Poland implemented ADR directives, introducing major revisions to the mediation rules. Similarly, parallelly, India also amended Commercial Court Act in the year 2018, making pre-litigation mediation a mandatory provision. That is to say, before filing a commercial case in a commercial court in India, it is mandatory for parties to explore the possibility of mediation. India has also enacted a Mediation Act in the year 2023. Now coming to the suitability of cases for mediation in India, Supreme Court in a case of Afcons Infrastructure Limited in the year 2010 laid down a brief categorization of cases suitable for mediation cases. First, all cases relating to trade, commerce and contracts are well suited for mediation. I would also like to mention the ambit of mediation is wider than arbitration. There are many cases where mediation could be done, but arbitration have a limited scope. Similarly, all cases relating to strained and sore relationships like some matrimonial disputes, custody of child dispute, maintenance, a property partition suit, any partnership dispute could also be referred for a mediation. All cases where there is a need for continuation of pre-existing relationship could also be referred for mediation, like easement rights, as I mentioned before, employer-employee dispute, any dispute in societies, residential colonies, apartments, these kind of dispute also be referred for mediation. Along with this, a consumer-related dispute, a dispute related to supplier, trader, manufacturer, service provider, these kind of dispute also be referred for mediation. In India, Supreme Court has set up a project committee by name of MCPC, which is Mediation and Conciliation Project Committee, for training and work related to mediation, conciliation in Supreme Court and different courts of India. So unlike arbitration or litigation, where a judge or arbitrator imposes a decision, mediation is a voluntary, flexible, confidential process. The goal of mediation is not to declare a winner or a loser, like solidarity movement, but to help both the parties to find a mutually agreeable solution. Coming to the point, who mediator is and what are his responsibilities and what are the qualities of good mediator. Mediator is a neutral professional. Mediator is a neutral professional and is also a service provider who helps two or more parties to reach an agreement. Unlike a judge of court or an arbitrator, a mediator does not impose his own decision. Instead, he guides discussions and help both the parties to find a mutually acceptable solution. Think a mediator as a bridge that connects two opposite sides, helping them to communicate effectively and find a common ground. So what are responsibilities of a mediator and how does he secure the end of justice? He do so by facilitating communication. He help parties to express their concerns, their needs, and he try to understand them and provide them ample of time to discuss, to present their case. He also ensures neutrality. He avoids favoritism and create a balanced discussion. There is also one important point I would like to mention here. In a case he is related to some party in past, he must make such a disclosure at the beginning of the mediation process. There should be no conflict of interest of a mediator. He should be absolutely a neutral person. Another important aspect, rather important responsibility of a mediator is he encourages parties for solving the problem. He identifies the issues, the basic issues which he identify at the point the parties are telling their story, their part of facts. He should be a good listener, and while listening, he should jot down all the important points and try to focus, try to take discussion towards those points and encourage parties to solve the problem and help them to think creatively to find the solution. Now, another important, very important point here. At the start of mediation, he must declare that whatever said during the course of mediation shall remain confidential and no part of the discussion shall form part of the court proceedings in case mediation fails. He has to ensure that the discussion remain private and do not influence external parties. He should also ensure all the parties, related parties, should be made part of discussion. If a single party is left out, he or she or a corporation, a party, whosoever he or she or it may be, they can raise an objection and the agreement entered between the parties could be challenged at later stages. So it is the duty of a mediator to ensure all the parties must have access for mediation and they should be present and duly represented at the time of mediation. Mediator also plays an important role in managing emotions of the parties. At times in matrimonial cases, parties are not very happy with each other. So he must ensure that conflicts, if any, remain professional and do not escalate. For this reason, it is very important that he explain ground rules in the beginning, wherein he should explain that he'll be conducting single session, he'll be conducting joint session, everyone will get a time to speak, a limited time frame will be given to everyone, and he demarcates the rule, he laid down the foundation for mediation. He should let parties speak, but in case if he feels the parties are unable to control their emotion, he must step in and use his position of authority to de-escalate the conflict, and at that very junction he can also opt for going for single session, have a discussion with a single party. So these are the key responsibilities of mediator. So let's take an example. Imagine there are two co-founders of a startup who disagree over how to split profit. If they go to the court, their relationship may break down permanently. Through mediation, they can have a structured conversation and arrive at a fair profit sharing agreement while keeping their business intact. Now coming to good qualities, the qualities that mediator need, which are the key factors which he must possess, essential qualities. As we discussed earlier, one of them is neutrality and impartiality. He should be impartial. He should give both the parties equal time and opportunity to speak, to bring their facts. He should be a good listener. He should have an excellent communication skills. If there are any misunderstanding between the parties, he should also try to clarify the same. He can also reframe their argument constructively so that none of the parties feel offended. But he cannot give any suggestion. He must not give any suggestion to the parties. He should be creative in problem solving, thinking out of the box, help parties to arrive at a unique win-win solution. He should also be aware of acts, laws, understand the legal aspect related to the dispute, to guide the discussion effectively without providing legal advice. Now, I would like to cite an example which came across me while I was resolving a dispute in a mediation. I was assisting them. This was a very unique case where a very small piece of land, rather a small plot, there was a dispute between 6 family members, a mother, her two daughter and 3 sons. And plot size was very minimal, very small. It can't be divided among them. So we had a single session in that case, and while having single session with the daughters, they suggested they need some assurance for their mother so as to allow her to give some funds on regular basis. They were ready and willing to forego if their brother agreed to the proposition. So while formulating the draft, while discussing the case, we had a very unique plan. One of them suggested it, and it was a win-win solution. So on that plot, on a ground floor, a shop and a small one-room set was constructed for a mother. With the rent from the shop, you go to mother for her expenses and daily needs, and upper 3 floors went to all the 3 brothers, and all 3 brothers used their funds to construct that building. So the case was resolved, and every family member were very happy at the end of the mediation. Now we would like to go through the mediation, how mediation process starts, how mediation process begin, and how it ends. It follows a structured process to ensure fairness and efficiency. So let's break it down step by step. At the starting of the mediation, there is an opening statement made by a mediator. He introduces himself and parties introduce themselves. Mediator explains the mediation process. He set the ground rules. He also tells the parties there will be no interruptions. He also explained to them confidentiality clause and mutual respect should be maintained during the course of mediation. Each party gets a chance to present their side of story without interruptions, of course. Then comes a storytelling phase where we understand what the dispute is all about. Here each party share their own perspective and explain their grievances. The mediator listens actively and identify the key issues. Third step, in mediation is negotiation and problem solving phase. The mediator encourages dialogue between the parties. The parties explore possible solutions and compromises. The mediator suggests alternatives if parties struggle to agree. So a company or an employee, if they are in dispute over their unpaid wages, an employee is demanding full payment while the company claims financial hardships, mediator may help them on installment payment. So these kind of resolution come forward. And another important step and the final step in mediation process is agreement drafting and closure. And believe me, this is the most important part. Parties at time agree on something, and at the time of signing of the agreement, they deny, they don't want to sign it for n number of reasons. So a mediator has to be very particular about things, about the discussions, about the agreement, about the disagreements, and jot down all the important points so that there is no dispute at the time of drafting and closure of a mediation. So if a resolution is reached, mediator helps to draft a formal agreement. Agreement is reviewed and signed by both the parties. And of course, if there is no agreement, then parties can explore all the arbitration or litigation wherever they want to go. But at the end of the mediation, mediator should give them some hope that at least we have moved forward from where we started. This is not the closure of the discussion. You can further try and go for a second round of mediation. So mediation never fails. It brings people together. It resolves issues, maybe not at the end of the mediation, maybe after some time they'll reach some kind of settlement and they remember the things they discussed over mediation. So mediation is always a successful story in one way or another. Let's say in a business dispute, two partners may agree to settle and for a structured exit plan. So this dispute or a resolution can also be arrived by way of mediation. So mediation have many advantages. It have many advantages over arbitration and particularly over litigation. Mediation is fast to resolve the matter as compared to litigation. It is cost effective, as I told you before. It is confidential. It is flexible. It preserves relationships. So in our discussion, through our discussion, we can conclude by saying that mediation is not an non-adversarial process where the neutral mediator facilitates discussion. A mediator do not make decision and he helps parties find their own solutions. It is faster, cheaper and more private than litigation. It can resolve business disputes, family disputes, even religious conflicts. This shows the power of mediation. And of course, the future of mediation is very bright, and which with online mediation platforms so much available and growing globally, it's going to help a lot. Now, I would like to invite, if you have any deeper understanding of mediation, if you can suggest me some real life scenario where mediation could have resolved the dispute. Can we take 2-3 responses over here? If someone want to have a discussion on mediation, else we'll continue with the arbitration part. In our next session, we will explore arbitration and how it differs from mediation. So now get ready for a deeper dive into legally binding dispute resolution. Any questions here for mediation or any other aspect of mediation? Please do let me know. So coming to arbitration, the most popular dispute resolution mechanism globally recognized today is arbitration. Now, who is an arbitrator and key features of arbitration? Now imagine there are two companies in dispute over a contract. Like in a case of mediation, they want to go to court and it's going to take a year. And they'll call a neutral person called arbitrator using the arbitration agreement, invoking the arbitration clause, who will hear both the parties. The tribunal will hear both the parties and make a final verdict. This process is called arbitration. An arbitrator is a neutral third party appointed by disputing parties to hear evidence. He will review their arguments and make a binding decision. This is the difference between mediation and arbitration. Mediator never makes a decision of the case, whereas in arbitration, arbitrator has to pass an award. He has to make a binding decision. Unlike mediators, Arbitrators act like private judges. They ensure that justice is served. It is based on legal principles and contractual obligations. Contractual obligations comes from arbitration clause. So what are the key features of arbitration? First one is binding decision. Unlike mediation, the arbitrator's decision, which is also known as arbitral award, is legally enforceable in court. Mediation never makes a decision. Rather, there is an agreement signed in a case of mediation, which is validated and signed and submitted in court. Thereafter, it can be enforced. Second important feature of arbitration is its flexible proceedings. Tribunals decide their own rules, procedures, and timeline. In India, after 2015 amendment, arbitration panel has to conclude this procedure of arbitration within 1 year span of time. If both the parties agree, they may take 6 months extension from the court. So it is a faster process. Another key feature of arbitration is that it is its neutrality and impartiality, like mediation. And lastly, it's expert decision making. You can have experts in a panel while deciding a matter related to mines, minerals. You can have expert from that department or any other expert in a case of telecommunication, an expert from telecommunication. So in a case of construction, finance, technology, where specialized knowledge is required to make a decision, a panel may consist of a specialized person with expert knowledge. A panel can use his or her specialized knowledge for passing an award. Types of arbitration. Now, what types of arbitration do we have? We do have institutional arbitration, we have ad hoc arbitration, we have international arbitration, we have domestic arbitration. Institutional arbitration, of course, is conducted by recognized arbitration institutions, naming few like International Chamber of Commerce, ICC, Singapore International Arbitration Center, SIAC, and India we have Delhi International Arbitration Center, DIAC, and there are many other renowned arbitration centers all over the world. So these institutions provide their own rules, venues, and panelists for arbitration. Institutional arbitration is common in large commercial disputes. Coming to ad hoc arbitration, it is conducted without institutional support, of course. Parties decide their arbitrators process. It is usually common in domestic and used for smaller disputes. So now we'll discuss arbitration process step by step. For invoking arbitration, there must be an agreement to arbitrate. Both parties agree to arbitration, usually through an arbitration clause in the contract. So it is very important that while drafting an agreement or an MOU, parties mention arbitration clause. Then there is selection of arbitrators. Party chooses their arbitrator, or in a case of institutional arbitration, they appoint the panel. In India, court have right to appoint the panel after filing an application before the court. Court can also appoint a panel. Then party making claim files a statement of claim, and opposite side files statement of defense. Both sides submit their arguments, their evidence, their claims. Then comes hearing proceedings. Arbitrator conducts hearings, listen to both the parties. He examines witnesses. He also reviews the document. Thereafter, award is issued, which is binding on both the parties. In most of the cases, arbitration award is final. Court may review it in a case of fraud or procedural unfairness. We are going to discuss this part at the end of this lecture. Now, there is an important point about arbitration venue. So, parties at the time of drafting an agreement may agree on a venue of arbitration. Like in a case of Vodafone versus India in year 2020, Vodafone invoked arbitration at arbitration venue under the Permanent Court of Arbitration in The Hague. Outcome of this tribunal ruled in favor of Vodafone's favor. It was a tax-related demand case. This case also reinforced the importance of international arbitration in protecting foreign investors. So, confidentiality, speed, enforceability, expertise, these are the advantages of arbitration. And of course, there are few disadvantages. Like for small cases, it is expensive, while mediation is not expensive as compared to arbitration. Arbitration cost can be high, especially in international disputes. Another disadvantage is that parties have limited rights to appeal. Unlike court cases, arbitration decisions are hard to challenge. Another disadvantage of arbitration is the risk of bias, which is always there in any mode of ADR, I would say. Then there are enforcement challenges in a case of foreign award, of course. Some countries delay or resist enforcing foreign award and making them difficult to implement. So, we have discussed about mediation, we have discussed about arbitration. So, why should we choose ADR over litigation? As we discussed earlier, because of its time, because of its cost, because of privacy, and also because of control over process. Because in arbitration, in mediation, parties are quite flexible. And final decision. And ADRs are less formal as compared to court cases. Any question, any discussion on this aspect, please do let me know. I'll proceed thereafter. I would like to proceed on future trends on ADR. Lately, we have seen the online dispute resolution is picking up pace. Development of online dispute resolution, widely known as ODR, has a wide spectrum, wider usage. Even in India, during pandemic period and post-pandemic era, we have seen development of ODR method. Nowadays, we have AI-powered platforms for digital mediation, for arbitrations. Many cases, many matters, many mediations in India are being conducted in virtual mode. I myself take 3-4 sessions in a single mediation to resolve the dispute. Suppose there are 5 meetings in a mediation, usually 2 to 3 meetings take place through virtual mode, as parties don't have to travel to Supreme Court. Long distances are avoided, their time, money, accessibility is good. So courts are also encouraging virtual arbitration, virtual mediation, and we are getting good results. There is also growth of institutional arbitration in India and in all over the world. If you see, commercial disputes of big MNCs, big corporations are being referred to institutional arbitration. There are also provisions for mandatory pre-litigation mediation, as I discussed earlier, in Indian Commercial Code. And there are many government reforms like Arbitration and Conciliation Amendment in the year 2021. And it made transparent and efficient so that there is transparency in a process. Till now, we have explored the fundamentals of alternative dispute resolution and its growing importance in the legal landscape. Now, I would like to draw your attention towards career opportunities in ADR and how to be a service provider, how to be a mediator, an arbitrator or arbitrator, as ADR expertise are very high in demand. You can become arbitrator or mediator by possessing a law degree or a specialized course, a certificate training from any of the good institutions like Indian Institute of Arbitration and Mediation, Singapore International Arbitration Center, Chartered Institute of Arbitrators. They do provide and enroll for certification programs. Many courts in India also offer mediator accreditation programs for legal professionals. MCPC, as I mentioned earlier, Mediation and Conciliation Project Committee, provides training to mediators in Supreme Court of India and various other judicial academies in India. And over a period of time, you can also build an expertise and reputation, gain experience. You can also publish articles, attend ADR conferences. You know, many arbitrators, mediators, they start as a lawyer and transition from lawyer as an arbitrator or a mediator is done over a period of time. There are also opportunities and careers in corporate arbitration and law firms. You can choose a corporate counsel role. You can also be a specialized in ADR in any good law firm. You can also be an independent practitioner as an ADR expert. Even many government and international organizations, they are looking for ADR professionals. Nowadays, if you see, there is a scope of ADR in sports arbitration, intellectual property and technological disputes. So ADR is transforming the way disputes are resolved in India and in worldwide. Whether you are a lawyer, a business professional, or a policymaker, understanding and mastering ADR, we can set up more arbitration centers. We can strengthen the current centers which are functioning. We can also encourage companies to use arbitration while formulating their agreements, promote digital and online dispute resolution, ODR, public awareness and training. ADR has potential to revolutionize the legal system, and we need legal reforms, public awareness, technological advancements for its full implementation. So till now we have discussed what ADR is all about mediation, how mediator works, what is the mediation process, what is arbitration process. Now we can discuss about European Union and Indian arbitration and mediation process. I would like to draw your attention toward the present situation of arbitration and mediation. Do you know there are around 50 million cases pending in India, as we discussed earlier? So what this figure shows? It shows that adversarial litigation system needs certain changes, and with the help of ADR and mediation and arbitration, the system is going to be revolutionized. Overburdened courts world over would be assisted by ADR. We are about to see a revolution in ADR system in near future. Growth of ADR infrastructure is exceptionally good, and in India, if you see, in last 5 years, with a good strength of trained mediators and arbitrators, is going to play a pivotal role in ADR. I have myself seen in last 5 years development of state-of-art institutional arbitration and mediation centers with ODR facilities. Now I would like to draw a comparison between European Union and Indian ADR system. As we know, both the European and Indian arbitration systems are based on the UNCITRAL model of law. Key differences in their legal framework, enforcement mechanism, and approach to international disputes. As European Union operates under Directive 2013-11 EU on consumer ADR and regulations, while in India arbitration is governed by Arbitration and Conciliation Act, which is based on UNCITRAL model law. European Union has a coordinated and unified system through decades of international legal institutional integration, and it's with a strong framework of cross-border dispute through ECCnet, which is European Consumer Centers Network. It plays role in assisting consumer to understand the right and facilities. It also facilitates communication between a trader and a consumer. In India, earlier the system was a bit complex with mechanism limited to cross-border dispute. But now, with better information technology and state-of-art institutional arbitration mediation infrastructures in Delhi, in Mumbai, in Hyderabad, we have seen multinational corporations considering as a destination, as a hub for arbitration and mediation. The European Union system is quite accessible through online platforms, and ODR is well established. In India, accessibility has lately shown a tremendous growth. As I was discussing earlier, that after easy access of mobile internet data, even in rural areas, in the far-flung destinations, particularly during and after COVID period, implementation of ODR has become very convenient, and it is accessible to every part of the country. So India has shown a tremendous IT growth. Well, regarding enforcement of award, an arbitrable award once recognized in a member state of European Union it can prevail over a judgment from another member state. And I believe there are certain requirements that are to be met for its enforcement. While Indian courts have a jurisdiction to entertain challenge to international commercial arbitration awards, so award can also be challenged under Indian Arbitration and Conciliation Act. So what are the courts' role? Indian courts are gradually taking more pro-arbitration view, but there are some relative delays, which is a matter of little concern. But still, if you see, with the latest amendment in many law, it seems a game changer, and it's going to expedite the justice delivery system. Like I discussed earlier, there is an amendment in Commercial Court Act which mandates pre-litigation mediation, a necessary provision, and there is setting up of big infrastructure for mediation and arbitration centers inside the court premises all over the countries with excellent ODR facilities. In European Union, seat of arbitration, parties can choose the seat of arbitration, which can be in a member state or outside the European Union. Cost and fees. In India, the cost of arbitration can vary depending on the place of arbitration, whether it's an institutional arbitration or an ad hoc arbitration, what is the strength of tribunal. However, a schedule of fees has been provided in the Act itself, which provide a formula for determination of arbitration fees, and this brings transparency to the parties so as to allow them to evaluate their tentative cost of arbitration. Now finally, I am going to discuss about two key issues on arbitration. One is arbitrability of a dispute, whether a subject matter is arbitrable or not arbitrable. And second, and the most important point, modification of award by court and its implication. Regarding arbitration, arbitrability of the dispute. As we know, parties can resolve disputes through arbitration only when the dispute is arbitrable. Over the years, various courts has developed frameworks and tests to ascertain the extent of arbitrability. In India, Supreme Court, in one of its landmark case on arbitration, has laid down the Booz-Allen test. It determines the criteria for assessing the arbitrability of the dispute. In the case of Booz-Allen and Hamilton Incorporation versus SBI Homes, in 2011, court recognized three conditions that has to be satisfied for a subject matter to be referred for arbitration. First is the dispute must be capable of adjudicating and settlement by arbitration. Second, the dispute must be covered by arbitration agreement, meaning thereby a provision, a clause regarding arbitration is already there in the agreement. Third, the parties must have referred to the dispute for arbitration. Honorable Supreme Court further laid down 6 categories which are incapable of being settled by arbitration. And these categories are disputes relating to criminal offences, matrimonial dispute, which includes divorce, judicial separation, guardianship matters, insolvency and winding up matters, testamentary matters, and of course tenancy related matters which are related to eviction of the tenant. These 6 categories are incapable of being settled by arbitration. Thereafter, in the Vidya Drolia case, it redefined the arbitrability in the year 2021. In India, Supreme Court laid down that mere existence of a special statute dealing with certain dispute does not ipso facto renders them non-arbitrable. It laid down a 4-fold test to determine non-arbitrability of the dispute. This was a 3-judge bench court. So the first test was when dispute related to actions in rem, that is disputes which are not in personam, it is against the word, this dispute is not arbitrable. Second, when dispute affects third party rights, this dispute is not arbitrable. Third, when dispute relate to inalienable sovereign and public interest functions of the state, Meaning thereby, let's say, if some criminal offense has been committed against the state, it will fall under the category of, under the ambit of sovereign functions and is non-arbitrable. Fourth, when the subject matter of the dispute is expressly or by necessary implication non-arbitrable as per mandatory statute. It was also held an arbitrable tribunal could adjudicate the civil aspect of fraud, coercion, undue influence or misrepresentation in a civil or commercial disputes unless same is expressly barred. So the current legislature and precedents of Indian judiciary aims to resolve the tussle between who determine arbitrability by extending autonomy to arbitral tribunals and re-emphasizing on the principle of competence. Now coming to the second part and the final part of this lecture is modification of award by court and its implications. One of the key factors of arbitration is finality of the arbitral award. The confidence of the parties is based on the fact that after contesting the case, after going to the arbitration, there will be a finality of award. And if the award is kept pending for long and it is not enforceable, this brings trust of the parties down. The faith of the parties regarding the process of arbitration is shaken. So one of the key factors in achieving finality to arbitration is by limiting the interference of the courts with arbitral award. Section 34 of Indian Arbitration Act is a mirrored image of Article 34 of UNCITRAL model law. Under this, the grounds of challenges are jurisdictional ground, that is when there was no valid agreement for arbitration. Second is procedural ground, where the parties were not given equal opportunities during the course of arbitration. And third is substantive ground, where the award was mistaken in law. In a landmark case of McDermott International in 2006, Indian Supreme Court observed that 1996 Act makes provision for the supervisory role of the courts for the review of arbitral award only to ensure fairness. The court could intervene only in case of fraud, in case of bias by the arbitrator, or violation of natural justice. They cannot correct errors of the arbitrators. My observation on this is the basic premise for the arbitration process is minimum judicial intervention, its cost effectiveness and finality of the award. Therefore, the power under Section 34 of the Act must be used with great caution, as the supervisory jurisdiction of court provide narrow scope for intervention in arbitral awards. In Singapore, under Section 49 of Arbitration Act 2001, it gives narrow scope for the court to vary from the award. This is a power under Section 49 of Singapore's Arbitration Act 2001. This is a power to modify the award within a very limited scope. For example, in a cases where there is a patent error on law committed by a tribunal in respect of a part of the award, such orders must, however, be made in exceptional circumstances and to meet the end of justice. And this would, of course, be consistent with the spirit of arbitration scheme. Lately, one such order was passed by Honorable Supreme Court in India to meet the ends of justice. This was in SsangYong Engineering and Construction Limited versus NHAI in the year 2019. In this case, court modified the award under Article 142 in order to do complete justice between the parties by invoking powers under Article 142 of the Constitution of India. So in the end of this lecture, I would like to say ADR, alternate dispute resolution, is no longer just an alternative. It is becoming the primary method for resolving the disputes worldwide, whether you are a lawyer, you are an entrepreneur, or a policymaker, mastering ADR will give you a strategic advantage in the legal profession. Now I would like to invite any questions or discussions on my lecture today. I would request mediator, the moderator, kindly enlighten us, to let us know how to proceed further. If there are any questions, please let me know. I would love to answer those questions. Thank you so much for your time today. Thank you for inviting me as a guest lecturer. Thank you so much and good evening.